So once again, welcome to this Data Protection Network webinar hosted by Bristows. We've called it Cookies and Yet More Cookies. We described it as Are You Suffering from Cookie Bloat? And we thought in the Data Protection Network that we would give us an opportunity together to look at the challenges that we are currently facing, look at what's coming down the track, question why we've been getting so many different variations on cookie notices and so on. I'm Robert Bond from Bristows, and I'm joined by Steph Elliott from Opt4 and Mike Bond from News UK. I'm going to get them to just briefly introduce themselves, and I'll turn to my right, Steph.
Hey, good afternoon, everyone. Thanks for joining us. My name's Steph Elliott. I'm an associate with Opt4. We're a data protection consultancy. We provide advice to a variety of clients. I've been working with Opt4 since about 2008. Prior to that, I had various roles, companies such as Experian, in looking at their data and their data marketing.
Thank you. And turning to my left, Mike.
Thank you. So my name is Michael Bond. I'm the Head of Data Protection and Commercial Data Protection Officer at News UK. Some of you will know our brands as The Times, The Sun, Unruly, and various others, including Wireless, so Virgin Radio, etc. I've been at News for nearly 4 years, and I'm intimately acquainted with the issues around e-privacy and cookies.
Thank you. Okay, so what are we going to look at? Well, we've done the introductions. I'm going to move on in a second to some polling questions. Then Steph's going to take us through the overview of the cookie rules, where we are and where we're going. And then I wanted to thank everybody that sent in your questions, which we distilled down into about 12 or 13. And to the extent that Steph and Michael, as he jumps in, haven't answered them as we go through, we'll turn to the remaining questions that are left towards the end. And jumping almost to the end, so that I remind myself now, we do hope that the conversation will continue. So you will see on the last slide that we will be putting up a hash for you to carry on sending in the questions, participating in the debate through the Data Protection Network. So if we move to the polling questions, we've got 3 of them. And I'm going to get Alicia to launch the first one, which we try to make as simple as we can. Do you think consumers, users, understand how cookies are used and, I suppose, the way they collect data? It's simply a yes or no. These are anonymous answers, so I'm really just looking to get a feel from those of you that are on the webinar. Is it a yes or is it a no? We'll take a look at the percentages before we close this. I'm grateful to you for jumping in with your answers here. There's quite a lot of you who have gone for no, little awareness, some awareness. Interestingly, the least number of percentages is for yes, everybody understands what cookies are about, and I guess that's the answer we were rather expecting, so thank you for that. And then turning to our next polling question, have you in the business conducted some form of impact assessment, or at least an audit of what third-party website cookies you use or allow? This is something that feeds into what Steph's going to be talking about. So again, it's yes or no, but we've given you some variations on that theme. And I would hope that the answer to this is yes, we have done at least something. Knowing what good companies are signed up to the webinar, it's not surprising that a large number certainly are saying, yes, we have done an audit. Interestingly, still a percentage saying we are planning to, and a very small percentage saying, no, we have not. Maybe that was tongue-in-cheek. Okay, thank you for that. And then we wanted within the Data Protection Network to think about at some point sending the results of what we learn from today and what we get in feedback through to the ICO so that they get something from the trenches, from the coalface. So I simply wanted to know, would you like to take part in some sort of survey or insight on cookies, the current PECA, and where the draft e-regulation is, or where we would like it to go? It's a yes or a no, please. And for those of you that aren't sure at this stage, I'm sure that's something that you can feed back into our discussion. Okay, so a good number saying, certainly 2/3 saying yes, and that's great, and we will come back to you after the webinar when we can formulate some sort of survey, and I'm sure that will be very much we will be taught by the further discussions and questions that we get. We've got a lot to cover, and I'm going to get Steph now to go through the slides that he's prepared, and I know that Mike and or I may want to jump in as appropriate, or Steph might surprise us by asking to talk about a slide that we know nothing about, Steph. But okay, over to you. Thank you.
Yeah, thank you. Yeah, hopefully you'll see, some of you might recognize these images. They're actually from a 1998 single, We've Come a Long Way, Baby, and Right Here, Right Now. And so what I wanted to do was give you an understanding of, we have come a long way in terms of data protection. Data protection has been going on for a period of time. There's a lot of information that's associated with this, and GDPR coming in didn't provide a totally new law. It sort of cemented law and legislation and guidance that's already there. And so what I wanted to do was take you through that and say how we've got to where we are today, but also to answer the question of what do we have to do right here, right now. If we can move on a slide. Cookies, are they on the menu? If you go to the ICO site, this is the information that you'll find in terms of your data matters. The ICO have done some analysis. The latest update they've got is that they've had various complaints. And I think the interesting thing about this is that the date it goes to, 2015, 2016, Q4, and the index, which goes up to 70. So it's showing that generally consumers aren't complaining to the ICO about this. And you might say, well, actually, that's because cookies aren't that important to consumers. I think what you need to then look at, and this is the whole thing with cookies, design and how we design systems and solutions has two impacts. It communicates information and it facilitates information. And if we do move on a slide, this is how you would go to actually record yourself against that, that bar chart. You have to go to the ICO website, you have to scroll down quite a long way. You report your concerns and you go through quite a convoluted user journey to actually complain about cookies. And I think this is one of the areas where cookies don't have the visibility to highlight how concerned individuals are from the ICO. Maybe that will change. If we move on to the next slide, I'm a great believer that I think cookies are the patsy here. I was fortunate enough to be invited by Northumbria Police on a speed awareness course. The speed awareness course was because I had abused the speed limit, not because I had abused the accelerator limit. The accelerator is there in a car for a number of reasons. And if you abuse the accelerator, you break the law. If you use the accelerator the way it should be, you've got a functioning capability that's very useful. And so I think I haven't got an accelerator policy. I haven't got an accelerator notice. My accelerator, if I abuse it, I break the law. And it's fairly clear, if I go faster than the speed limit in a designated area, I will break the law. And I do believe that cookies have borne the brunt of the data protection regulations. And I think it's important that we understand that cookies actually facilitate a purpose. And one of the key things is that we understand the purpose that the cookie is actually facilitating rather than look at the cookie. I think that's a key thing to take away from today. If you move on to the next slide, a lot of people are asking about the e-privacy regulation. You'll be aware of PECA. E-privacy regulation is the regulation that was due to come in on the same day as GDPR. and it's going through a series of reviews. I think the major issues here is the change that has recently come out, which highlights the fact that it shall now apply from no longer from the 25th of May 2018 to 1 year from the date of entry into force. Gentlemen, I don't know, my anticipation is that this is not going to be 1 year from today. I anticipate it's going to be 18 months, potentially 2 years going out. Would that be fair?
Well, certainly we're hearing from Europe there are a lot of political issues still to resolve around e-privacy, and I think more generally Brexit might be playing a role. It could be that the next presidency have a lot more work to do, or that this one actually decide that they're going to do something meaningful with the text. But I don't think that we should be complacent, even if we do have 18 months, 24 months before we get the regs. We can be doing an awful lot of work now.
Fine.
Yeah. Agree with that.
I mean, the reason for showing this slide is if we move on a slide, this right here, right now, we have to deal with the regulation as is now. I think that's one of the things that I think a lot of people were waiting for this legislation to come into and to be enforced. We've got a 2-year window where we've got to work with the law as is, and I think it's important that people move away from relying on this coming in and saying we're going to move to that position when it comes in, to actually say, how do I comply with the law as of now? And so what I've done is, this is my history lesson. This is effectively the hokey cokey of e-privacy. What this is doing is saying that actually the law has evolved from, say, 2003 when PECA came in, where we had an opt-out facility. But what happened is that there were some changes to the law over time. In 2009, we had a new law that came out, a directive, that actually then moved us to a European directive that stating that we had to move to opt-in. That was enacted into the PECA guidelines in 2011, which is effectively the cookie law. The cookie law came in, and that highlighted the fact that we had to have info and then opt-in to cookies. But what happened with that was that the ICO actually, on the 24th of the 5th, 2012, actually then provided some guidance where we moved to implied consent in terms of opt-in. So we've sort of moved around in this. I think there's a lot of confusion about what is opt-in, what is opt-out into cookies, and what needs to be put in place.
If I might make a point there, the ICO's guidance was incredibly important when it came out, and those of us who were working back then in sort of 2011-12 were lobbying government quite hard for a sensible implementation of what could have been a really awful bit of law. And they understood that actually implied consent in the right context, with the right information based on what the individual was trying to get access to, was probably enough. And I think there has been an evolution in the minds of the legislators, but that is a really important point. And even now, the regulators like the ICO are trying to understand what consent really means. And we'll come on to this later, I'm sure, but I'm very keen on the idea of meaningful consent rather than hard opt-in, soft opt-in, whatever it is. It needs to be relevant for the individual who has to understand what consent means.
Yeah, and if I could just add to that, when we were doing stuff with the International Chamber of Commerce way back when, I think we were trying to counter what seemed to be the feeling by the regulators, or if not the regulators, the bureaucrats, that all cookies are bad. And we've seen over the last few years that actually the regulators are saying there are cookies that are good, and this is why you don't need opt-in for something that's strictly necessary, but you do at least need information.
Yeah, fine. I totally concur with that. I think that's important to highlight that. I think one of the things that happened after the ICO guidance came in was that we've got into this environment now, which I actually went onto the ICO site, and that guidance is still available today. So that guidance is still there for people to review if they want to have a look at it. I think one of the other things that's quite important to notice is that PECA in 2015 also made some amendments to a definition of how you actually break the law here. Whereas previously, if you contravened PECA, it had to be proving a substantial risk to an individual, and that's now been removed in 2015. So technically, the legislature has got some ability to actually fine and be slightly harsher than they were before 2015. So that's the PECA law, and that's what we're operating under at the moment. You would have seen that the 2018 Data Protection Act came into the UK, and if you have a look at that, if you're interested in all 354 pages of it, if you go to 338, that highlights the fact that PECA is still applied today, and that's what we're operating under today. So that's effectively where we are. That's the history, as I say, our hokey-cokey of cookies. One of the questions I get asked quite a lot is, where do PECA and GDPR actually meet? And I think this is important to understand that the laws themselves come from two different purposes. One is there in terms of the protection of the private space of the individual, which is from the PECA regulations. And the second is GDPR, which is in terms of the processing of personal data. And so what we tend to find is that you have to, this concept of consent is consent to what? Specificity of consent, excuse me, put my teeth back in. You need to be clear what you're actually asking for. And under GDPR, consent is just one of 6 bases on which you're processing data. In the same way as I speak about my accelerator here, if I'm using a cookie to process personal data, I have to have a basis for processing that personal data. And if I use a cookie to facilitate that, I have to make the consumer aware of that unless it's strictly necessary. So I think the first question here is, going back to the cookies that are set, is to understand what is the cookie being set for. It's coming back to the purpose of the cookie. The key thing there is that the way the technology works is that you often have to ask consent for the cookie straight up as you go onto the browser before you can get into some of the purposes, but I think that requires businesses to look at how they present this information going forward. In terms of GDPR responsibility, my children, thankfully, have now left home. We did have 1 or 2 parties. I'm sure some of the people on the webinar will have had children's parties, or when I say children's, young adults parties, might even have been to a few of them themselves. But effectively, cookies are like parties, in my view. Michael and Robert, I could invite to a party, and I'm sure they'll be great company, they come along. But if they brought 20 of their friends along and didn't tell me about it, I might have trouble catering for it. And I think this is one of the things that we start looking at in terms of cookies, is that you've got a responsibility as a website owner. I think you've got to look at that in the concept of your responsibility under GDPR. I've got to recognise Reuters Institute, Tim Libert and Rasmus Leis-Nielsen actually provided some information recently, which talked about the fact that cookies facilitate a number of different functions on a website. And most websites, my dad thinks that a website comes from one place. My dad is 80, he goes onto the website, he looks at it, and he doesn't understand that it's actually made up of various objects which are often delivered from a variety of different sources and different organisations. But ultimately, what a web page does is it provides various functionality to the users of the website, and that can be for a variety of different things. But I think it's important that as a business you understand what functionality your website is providing to whom and how that is being provided. That ultimately comes down to the use of the cookies that sit behind that. If you look at GDPR, the GDPR landscape requires a data controller to own the processes that they make available to their data subjects. Ultimately, we're on the right-hand side here. The right-hand side is data controller, is the website owner. The website owner invites people onto their website. It invites people to the party. Now, if you are inviting people to the party and you're not strict about what they can do and who they can make available to come to the party, you're in your Facebook scenario in that you don't understand the processing that's going on there. And if you're interested in terms of the requirements, you go back to some of the working party guidance talking about definitions of processor and controller, and it defines what you should do with various examples, specifically regarding some websites as well, if you look into that guidance. Just moving forward, so the key thing here is that your web page is an object, is made up of objects, and you need to understand the purposes of those objects. You need to understand who provides that functionality, and you need to understand what is the relationship with yourself and the provider of that functionality. And what we're increasingly finding is that whereas people are putting objects onto websites, the websites will often be using a third party. And if you pay for the service, you potentially are in a processor arrangement, you're controller to processor. However, sometimes you'll be putting free technology onto your website. And ultimately what you're doing there is you're surrendering or you're enabling somebody to control the purpose of the use of the data. You become a controller to controller relationship, and you need to be aware of that. So looking through the guidance, if you look at the guidance from the cookies, 2012, we were told to do an audit of our cookies. I'm sure everyone has done that. It might need revising. But ultimately, what you need to do is look at the guidance for data protection impact assessments, specifically regarding complex processing. And the key thing here is to go onto your website, look at the objects, look at the purpose for why you're doing something, and then understand whether the processor is processing to your instruction or they are actually a controller going forward. Because I use a phrase with accountability, which is a key thing for GDPR. If you can't explain it, you can't defend it. And if you can't explain it to yourself, you can't explain it to your data subjects. And therefore, you're going to miss one of the key tenets, again, of transparency in terms of data subjects. And so ultimately, you might have a leaking bucket of data, and you need to understand where that data is moving to.
Who does the audit? Is it marketing, compliance, IT?
I believe it's a mix of both, to be honest. I think a lot of the time, a lot of the cookie audits I tend to find is that people look at cookies and then try to identify the source of the cookie. But ultimately, sometimes people use the phrase third-party cookies. I think there's a lot of what I call fourth-party cookies, which are sometimes served by a third party. It's important that you understand the key relationships and then build into those relationships the fact that the supplier will not provide fourth-party cookies, or if they do, they comply with GDPR.
It's interesting sat here, and that the publishers on the webinar will be tearing their hair out, screaming at the microphone, going, "If only it were that easy." I think we've been struggling for a number of years to understand who's placing what technologies on our website, because we would love to stop data leakage, but there's an awful lot of issues regarding transparency in the ad tech market particularly, where we simply don't know. And the real kicker with some of this stuff is that those ad tech companies and agencies put restrictions on our ability to actually look at what that technology is doing, that you won't unpack what the pixel is made up of, that you won't see what data it's scraping off the sides. So it becomes very difficult. And I think we are at a bit of a watershed moment. What GDPR has done is it's lifted the lid on what a lot of ad tech companies are doing, because for the first time, rightly or wrongly, they think they need consent for some of this stuff, and they need to come cap in hand to the publisher to say, would you mind facilitating that for me? Because I've just realized for the first time that I'm not allowed to do it. So the publisher is in a wonderful position where actually for the first time, it can really dictate what technologies are on its websites, for what purposes. But I do agree with you, there's an awful lot of work that a publisher still has to do to get to that point.
And timely, really, because what we've got is looking at the IAB framework. For those of you who are not in the ads space, the IAB have provided a framework very much for programmatic advertising, ensuring that the suppliers within the daisy chain of supply have suitable consent for not only the cookies that they serve, but also for the purposes on which they're utilizing the data. And this is where I think there's, Mike, you're spot on, the challenge here is the complexity of the data providers within this. What has built up is a sort of ecosystem of a variety of data suppliers, a lot of them doing things with data which technically is personal data, and therefore they require under GDPR to comply with the law.
Yeah. I think it's very interesting. GDPR's certainly already had the effect of thinning the herd, if you like. So there will be consolidation in the ad tech market, where only the biggest players or ones that demonstrate the most value will exist. And what I would say to publishers and ad tech companies out there now is transparency is key. If you can demonstrate real value and be honest with your publishers, they're the ones that are going to remain and really benefit from GDPR. And that's really, I think, what the lawmakers set out to do with this stuff. It was to say, let's not make life harder, let's make it easier for people to understand what's going on, and it benefits everybody. Just talking about the IAB framework, I do think that this came out of absolutely the right place, that someone had to do something to try and enable everyone in the marketplace to comply. I do think that the implementation of it requires work. News UK are members of the IAB, and we are certainly supporting that process.
Yeah, I would agree that I think the IAB framework is a good first start. I think there's still some work to be done there to make it more transparent and more effective. And part of that is down to some of the policing. And I think one of the things that's important to get across to people, we were asked the question, how do I make myself compliant? There's still a lot of work to be done to actually come up with a compliant, robust solution in some of the industries, specifically regarding the transfer of data through cookies.
I think it's interesting you may come onto this, what you think compliance looks like in this space, because I think it's a bit of a red herring in the sense that every publisher will be different. Every ad tech company will be different. And what compliance really means is up to you, your website, and also your appetite for risk.
Yeah, and actually even the ICO guidance makes it absolutely clear that they are not prescriptive as to what is an appropriate cookie statement, appropriate policy. It's up to you to define it. And that, of course, falls completely in line with the whole notion of accountability under GDPR. You set what you think is your own limit. It's the bit that interesting listening to you both so far is that we've talked, I suppose, inevitably everything from the business point of view. I'm still wondering how much of this really matters to the consumer, or is that playing devil's advocate?
Well, the consumer's interests are absolutely at the heart of this, I think. Okay. The way that news is looking at compliance is if you take two of the most widely read online websites in the country, nay, the world, you couldn't put a splash page up there, regardless of whether your consent management platform thinks that that's the way compliance should be. John Witherow would have a heart attack if you tried it. We have to come up with something a little bit more pragmatic. And if you look at the Times customers, their audience, they are going to be much more switched on, and indeed they are, and they expect better from the Times than something particularly clumsy. And I think what frustrates me more than anything from a practical point of view is if you get in someone's way between them and the content that they're trying to consume, that's fine, as long as what you're doing there is helpful. I think where you have these big splash pages where you can't move forward, and it's a yes, accept all cookies as a big flashing button, and then you have to go through 6 or 7 clicks to actually be able to choose what you're doing. Well, that's incredibly unhelpful. And let's face it, as Robert's mentioned or alluded to, the customer doesn't really care. It's up to you as the publisher to understand what you've got and to help keep the bad guys off those sites.
I think on that point, Michael, spot on again. I think what you've got with consumers is that consumers are involved in a process, and that process has got a design to it. And design is there to communicate and facilitate. A lot of, in my personal view, a lot of the consent platforms we've got currently aren't consent. They're tick the box quickly and get through to the next component. Mm-hmm. And you start looking at this, and from a data controller perspective, this is where you're starting to look at some of your management information. So, for example, if you've got a consent pop-up and everyone clicks on it in 2 seconds, that would suggest to me that people aren't reading it. That's the sort of accountability that I think people need to review. And also, you look at the consumer, the ICO and the guidance is clear in terms of if you are putting something into place, then test that. They just talk about hall tests. I'm showing my age there. I've been at a hall test. But there's a lot of work that can be done to actually justify that you have put in place a solution. and that it's aimed at the consumer.
I think to any of the regulators, if you're listening, it is a work in progress, and I think to even get to a point where you have a working CMP that actually has the IAB framework embedded in it is a big ask in itself. I mean, we started looking at this months ago, and simply trying to choose the right CMP for us was a big challenge. And now we've got the CMP in place and we're trying to instigate the use of the IAB framework. It doesn't always work. There are constant releases, constant fixes, lots of bugs. Sometimes it won't pass consent, sometimes it passes too many consents. And it is definitely a work in progress, much to the frustration of our tech teams who are there saying, I don't care what it does. If the website goes down, there's no point doing this at all.
Yeah.
So there's a huge number of balances to try and strike. The consumer is definitely king in this, but you've got your tech teams on one side, you've got the compliance team banging the drum. I'm sat there, you know, saying, please get on with it, guys. And then the team's tasked to deliver this stuff. It is a huge effort for everyone out there. So if you're sat there thinking that the world's about to end because you've not done it already, please don't, because everyone out there is still working on this.
And to back that up, the analogy I use is that my maths teacher, when I was doing my O-levels, Mr. Reynolds, told me when I was doing my O-levels, it doesn't matter if you get the answer right, but show your workings, make sure you get your workings. And I think this is one of the things that DPOs and organisations need to do is, it's not feasible to sit back and say, this is too complex. I think what you've got to do is you've got to start looking at this and saying, well, actually, we do understand the processes that our website operates. We do understand that currently we utilize this technology. We have reviewed this technology and we do understand the process. And the DPIA, if you look at the guidance again from the ICO, talks about the types of processing that should require a DPIA. Website tracking is in there. You know, there is a lot of information, I think, historically, which if you were to find yourself stood up in court, it would be very difficult to say, well, actually, I ignored that component.
Yes. Okay, but we interrupted your flow, by the way, Steph, so
that's
back
okay.
to you again.
Very, very relevant questions. Yeah, this is the IAB framework, and if this effectively passes consents down the daisy chain, the purpose here is that you transfer these across. The publisher captures the consents for the individuals who are in that process. And again, I still believe that this is moving away from what I call a consent framework to a preference framework. Ultimately, consent, you only require consent if you're processing under the basis of consent or for setting a cookie onto a terminal, somebody's terminal equipment. And so there's an element here where the framework, I think I'd agree with Mike, it's in the right direction, but I still think there's some work to be done on that as we move forward. And this highlights this, partly because I think the IAB have done some great work, but this is a sort of self-reporting tool. The suppliers are reporting under what basis they're processing data. And this was a piece of analysis that we did about a month and a half ago. So there's more companies now on the ICO framework, the IAB framework. But ultimately what you've got is you've got some companies in the first column who are processing information storage and access on the basis of legitimate interest. That immediately goes against PECA. Some of the other guidance you might actually wish to process on legitimate interest. Behavioral targeting, I look at this from a perspective of if you're on your own website and you're using someone's behavior to target, I would suggest you potentially could go on legitimate interest on that, provided you've done a balancing test and you've taken into account the rights and freedoms of the individual. Behavioral targeting off-site, I would say you go on consent. And I think you need to have a look at that and ensure that you've got the recognised sort of mechanisms in place to do that. So the big question, what are the risks? I was frivolous partly about my accelerator. I actually did 44 in a 40 zone. I wish it was 42 because I might have got away with it. But ultimately, what's the risk of getting caught here? What's the risk that this is going to happen? And I think the ICO are reacting currently to the law and its implementation. They are updating a lot of their guidance and their notification. Unlike the speeding test, it's not black and white here. I think this is down to the individual companies to look at their processing, to be accountable for the processing they do and the basis that they put under, they operate under.
Well, we are incredibly lucky in the UK that we have always had and continue to have a very pragmatic regulator. She much rather have a conversation with you than get out her big stick and hit you with it. And for as long as that remains the case, then all businesses in the UK will have that opportunity to have that conversation. There are, of course, risks with getting it wrong. And I think were you to purposefully and willfully disregard the law, then that would be a different matter. But certainly from the publisher's perspective, there are bigger fish to fry than the regulator right now. We know that she's going to be interested in this area, and we know that she is looking for education to an extent from industry about what the issues are. So I think, and we've done a lot of work with the Association of Online Publishers to really show that the issues here are around transparency. When you look at the issues of Facebook and Cambridge Analytica and those kinds of uses of personal data and the means by which it's collected, it's the nefarious stuff they're really after.
Yeah.
But you know, of course, there are the potential for reputational damage, which I think is far more of a concern for people on a day-to-day basis.
But it isn't all about not complying with the law, and this is the lawyer speaking. I think of a lot of companies that are data rich, and the technology companies, even the startup companies, in fact, the only asset they've got is data. If you can't prove to the venture capitalist or the private equity company, or you can't do your IPO because your data is toxic, don't you wish with hindsight that you'd actually got a process that made your data worth the paper it isn't written on? And you know, that for me is key to even the larger businesses. If you're doing due diligence, and we are seeing the corporate lawyers thinking more about the value of information now and not just focusing on intellectual property, it behoves the business to say, if we think data is worth all this stuff, we really ought to have processes that make it worth what we think it's worth. So you're back to, are we transparent? Are we using the right lawful ground? Are we trying to do the right thing rather than pretending the law is here and we don't like it?
Yeah, I would. If you look at the concept, data is the new oil. We've had that bandied around for a period of time, and a lot of people are collating data with the purpose of determining the utility. I like that phrase. We don't know what it's worth. We'll work it out in the future. I think you're right. It's if data is the new oil. I don't keep oil drums under my desk. I don't keep oil that's out of date in my garage. Just, you know, there's the risk of flames and that sort of scenario. I think people are becoming more aware that data now has got a currency, and it's important that they do treat data as it has got that value.
So is cookie part of the refinery then?
As I say, I believe cookies, turning it around, cookies facilitate a process. And that's why I feel they are the patsy. Cookies, there are some fantastic cookies. I like going onto shopping carts and I like spending my money. And if I didn't have cookies to enable that to remember me as I came back, I'd find that a bit frustrating. So there are some good value for cookies. I think cookies, it's potentially then looking at cookies. It's the cookie itself isn't the danger. The danger is the database that sits behind the cookie.
Yes, or the process before the cookie is set, because I was thinking about, I like going online, but I have such a choice that if I am presented with a preference that is too complicated, I move on. So there's lots of practical challenges. Anyway,
I just had one more point if it's okay.
Yeah.
Just rowing back to what is the risk here. My own personal view is that if you are providing customers, your audiences, with something that they want in a way that is easy and accessible, then they are not going to complain. It's as soon as you start doing things that irritate them, that they don't want, that get in their way, that will drive complaints to you in the first instance, and where you cannot resolve them or you don't resolve them to their satisfaction, to the regulator. And what the regulator will do is they'll sit there and they'll watch these complaints come in, they'll look at themes, and eventually they'll say, right, enough is enough. But if you get it right, if you give the customer what they want and you look out for them, so you are transparent about what it is that you're doing, and there's a whole data governance piece that sits underneath that, I totally get that. But if you're transparent, you give them the control and the meaningful control to choose how their data is used, to exercise their rights, then no one will complain and there will be no risk, regardless of how compliant you are.
That's sort of borne out as well, I think, by the current scenario. If we move on a slide, if you look at the ICO in terms of its cookie tool is technically not compliant with PECA under the new regulation, and it accepts that, and it says that it's moving towards that. So the ICO is moving in this way. A lot of the ICO guidance, I think, Mike, you're spot on again in terms of the fact that it's the 2012 guidance is still in place. There's no new updated guidance in terms of cookies. So, but I think the key thing to continue, or maybe stretch the analogy too far, this is the direction of travel. You'll see with the e-privacy directive that's in at the moment, the regulation that's coming through, we do need to be clearer in terms of why we're processing this data and be clearer to individuals what we're going to do with that. And if you move forward, I would also agree that the component here is within the advertising space, it's the two outliers who are going to bear the brunt of consumer frustration. I think it's the advertiser who's advertising on the publisher's site and the publisher who will bear the consumer disquiet about this. If people are processing data within this eco-structure and it is not deemed to be compliant, or people are unaware of that, they won't go to the eco-structure, they'll go to their publisher. With the IAB framework, I've been through looking at a couple of the suppliers, and unfortunately my maths teacher was fairly good. Madame Moss, my French teacher, wasn't particularly great, or I didn't pay attention, but some of the French privacy policies that I can click through to, I do struggle to understand.
Okay, thank you. We've got about 12 minutes or 15 minutes left, and if any questions have come in while we've been talking, do please push those round to me. But we received, thank you, hundreds of questions in advance, and I distilled those down into 2 slides worth. And I'm just looking at these. Do we know what a compliant cookie notice looks like? And I'm rolling this in with the first question. So the first 2 together. Do we think we need a separate cookie policy from or statement from the privacy notice, or do you still think it's possible to roll these in, or does it matter if in fact what we're doing is layered? What do we think?
Well, take the last question first. I think layering is an incredibly useful tool, and in fact the ICO's guidance, rams this home every single time. It's about making as much information available as far as the person wants to go with it. At the very outset, regardless of where you put your cookie notice, it needs to be accessible, normally 1 click away from the individual at any point wherever they are on the website, as your privacy notice will be anyway. And I think that the distinction between having a privacy notice and a cookie notice is starting to dissolve now. There used to be that distinction because it was helpful in terms of, well, cookies might not be collecting identifiable information, personal data. And I think with the definitions that we're starting to see rolled out in Europe for the GDPR, the new rules in California and other places, that actually that distinction between cookies collecting different types of information as opposed to when it's put through a registration form are disappearing. It's all personal data now. So I think you could usefully put it in the same place, but it's ultimately about providing as much information as that user requires. And what does a compliant notice look like? well, certainly listing out the categories of cookies that you've got on there, which third-party vendors you're working with, and what they do. That's an awfully good start.
Yeah, and we see, and this is the third question up there, different approaches. So, you know, I mean, I look at some policies that are massively detailed on every single type of cookie by its name and what it does, etc. And others that are still using what we did in the ICC, strictly necessary, performant, functionality, tracking, targeting. Do we need to drill down into the detail of every single cookie, Steph?
I believe that potentially layering of privacy notices is the way to go. I think we potentially might need to look at the order with which we layer. As I say, I need a PR agency for the cookie. I think it should be a visitor notice onto your website. And the visitor notice should state something initially, such as, we do X, Y, and Z. And in order to do this, we use cookies. And you turn the conversation so that you're actually demonstrating the processing that you're utilizing under that. And maybe get the level of detail. You know, off the top of my head, you might even say, we use 15 cookies to do this. If you wish to find out more, go here. It should be yes, no, more information. And I think, personally, I think a lot of the cookie notices, or some of the cookie notices I see, I think we're treating consumers without respect. People are interested in this. I think sometimes we say, I've seen it, you know, with the technical stuff. You know, it's the phraseology that we utilize. It's almost like, don't worry your sweet little pretty head about that. You know, we'll look after that. I think we've got to be more transparent, as you say, in terms of that.
Yeah, and at the other end of the scale, I suppose there's still the argument that if you have a too complicated cookie statement, the average consumer will glaze over. And so I quite like your idea about being innovative in the way that you permission what happens next by being plain language, and that actually this is a win-win situation because we can only give you X, Y, and Z if you allow us to do A, B, and C. I mean, is that the approach that you guys are taking at News?
Well, I think it really depends on who your audience is. If you've got the register, for example, which is a tech audience, they want that level of detail. I think a really good measure of what people want to know and their understanding of it is the complaints that you see. So we have a data protection mailbox on our privacy notice, and it's not a short notice. People are reading the entire thing because they want to get in touch about this stuff. And sure, the complaints we see around cookies and the collection of data on the website are few and far between compared to deletion requests and SARs, but they are there. So we certainly don't treat our audiences any different to you or Steph. We would just say, what is a reasonable person's interpretation of what cookies do? And then you need a PhD to try and interpret that in the legalese.
Yeah. Okay. Is there a difference between, I'm just jumping down towards the bottom here, is there a difference as to how you approach consent or finding another legitimate purpose if it's B2B as opposed to B2C? Michael?
What a lovely question. In relation to direct marketing, are we better served by talking about direct marketing more generally, or are we talking in the context of cookies?
No, I think this one was actually direct marketing in general.
Fine. Well, the ICO has been very clear about its view on B2B marketing, that generally if you're sending stuff in the context of work and that person would expect it, get on with it, provide them an easy way of opting out. It's work, for goodness sake. I do think that it's worth being still transparent, because at the end of the day, that person is an individual and they have rights. But I think, you know, that the ICO has been quite relaxed on that. I would say it's sort of a slightly movable feast though in the B2B market, because the ICO seems to have changed their guidance 2 or 3 times since I last looked. And that's quite understandable. But generally, consent isn't needed for B2B marketing. you can rely on legitimate interests and provide people an opt-out. That's my view anyway.
Yes, Stefan.
I think the interesting thing is to look at the e-privacy regulation that's coming through, moving away from what has traditionally been the phrase subscriber to end user. So I think this is something that is going to come out going forward. There is a lot of lobbying going on regarding the exact phraseology, and we get into legal areas where that's your expertise rather than mine. But I think that, again, it's coming down to, if you're processing personal data, get a lawful basis, have that lawful basis, and be transparent about how you utilise it.
It's also about doing the work behind that lawful basis, though.
Yeah.
It's very easy to say, we've got a legitimate interest, so we're going to use that. I think it's very important to actually do that balancing test. A big plug coming out here for the Data Protection Network. We have done a huge amount of work on what legitimate interest assessments look like, what they should contain, and that argument and balancing test that needs to be conducted. So I would urge anyone who's not looked at legitimate interest assessments to go to the Data Protection Network site and download the guidance and take a look.
Can I just add an extension onto that? I totally believe that the Data Protection Network's legitimate interest tool is very effective. I think the one thing that organisations do need to bear in mind is that they do need to consider their consumer. And I think a lot of people might utilise that to, the answer is legitimate interest, how do we get there, rather than go through the process. And I think the value is going through the process, because often what you'll do is you'll find things that you can put in place to improve the rights and freedoms of individuals, rather than to say the answer is we currently do it this way, we currently utilise legitimate interest, go through the test, yes, we're okay. Because if the ICO comes in, they would expect to see that. And I think if you've set out this is the answer before you started, it hasn't got the same value.
And I think ultimately we will end up with case law
Yes.
on what is a legitimate interest, and it would be fascinating. I just hope it's not me that has to.
Let's just move to the next slide if we can. Pick up on the next set of questions. Is that okay? Should cookie consent be logged and accessible somehow in the back end?
From whose perspective is that? If that's the publisher or the company that's got the consent management platform, then absolutely. We're very interested in the consent levels that we are passing through to our vendors. It's absolutely imperative that we know that the consent process is working. From a customer's perspective, it's a very different proposition. It would actually probably be quite useful for an individual to be able to go through and see which cookies they have consented to and have that sort of ability to review and change their minds. And I don't see that working any differently to what email marketing you get.
Yeah.
There should be a preference center, and that's a great idea.
And we're seeing quite a lot of those now. Obviously, the other end of the scale is I've looked at some of those, and actually to set the cookie consents across 5 or 6 or 7 or 9, you almost lose interest. So you have to be persuaded to go through that if you're really going to buy from that site. But you can see that the controller is trying to do the right thing. Well, we've talked a little bit about when we see the e-privacy regulation being finalised. We've sort of decided it's not going to be in the next year, and I guess 18 months, 2020. What do you think?
I think there's a difference between when it's finalised and when it's published.
Okay.
I think with the regulation is likely to be agreed and published within 2 years. I do believe that the same way we're talking about PECA and cookies now, a number of years after the 2009 sort of regulation came in place. So I think there is a case law component here. It is the direction of travel, though, that you will have to be more compliant with that.
I do think that it's certainly not worth giving up. It's not a done deal. If you have an opportunity to get involved with lobbying at European level, if you know who your local MEP is, you should certainly think about making your opinions known on e-privacy. And that actually there does need to be a little bit more common sense put into the drafting. certainly we were of the view that this wouldn't be done for quite a while, but it does feel to me, and we're seeing out of various trade bodies looking at this, that there is a bit more political will now to get this sorted out quite quickly. So we'll see where the Austrians end up and what happens when the next presidency come in. But this should be on everyone's radar. It is as big a deal for organisations as GDPR, if not more so.
If I can just reiterate, I think this is going to happen in the future. I think a number of organisations thought we will wait until this comes in before we start moving in terms of what we're doing with cookies and transparency. I think what has happened now is that you have to be working towards this. I think it was your phrase, Robert, GDPR day, you have to keep running. And this is one of these, you have to keep running under the law as is, because whilst the ICO hasn't forcefully enacted some of the cookie legislation, I see this as happening years down the track, sitting there saying, well, actually, I've done nothing because I was waiting for the privacy regulation to come through, won't wash.
Yeah, absolutely. There's two questions at the end. I think one is probably for you, Michael, in terms of the publisher advertising agency. It's not specifically cookies, but...
So is this who's the controller and who's the processor?
Yes.
As you know, there are hundreds and hundreds of intermediaries in the ad tech space. It's proliferated, and it has become a bit of a free-for-all. If you can get your hands on the data, whether that's putting in bid requests for placement of ads on purpose, losing them because you still get the same data sets, which you can then package up and then retarget individuals or legitimately use the data. There is a huge amount out there, and the question here is who's responsible for compliance with this stuff? And I think it will ultimately depend. A really good example of movement in this space is Google. I mean, they have forever and a day been an internet search engine acting as an intermediary to all of the publishers and advertisers. And we have seen a significant shift in their market position of what they want to be considered as. And when GDPR came around, they issued a data protection addendum to an awful lot of their vendors and their publishers saying, hey, we're now a co-controller. And whilst they got the terminology wrong, they're not a co-controller, they just wanted to be a controller for the data they get. The intention behind it was blinding, in that they want to be able to determine how that data is used. And we're seeing other data protection addendums where other ad tech companies have cottoned onto the same idea. Hey, if we're a controller, we have much more say over how the data is used, where I think that's not necessarily responsible. If you are a controller, sure, work out if you are actually determining the purposes of processing and the means of processing, and then you probably are. But if you are simply a processor, make peace with that and do a good job of doing it.
Okay. And the last question up there, I'm going to read it out, and then I'm hoping that the three of us may in unison give the answer to this one. Is it still possible to work with pre-tick boxes to get as many consents as possible? No.
It's not a trick question, is it?
No. I think it was a genuine question, but no. The ICO is pretty forceful about pre-tick boxes not being appropriate.
Pre-ticking is very naughty, please don't do it.
Okay, we've reached the end of our hour, and so if we could just move on to the closing slides. I wanted to thank Steph and Michael very much for this. We put up there to follow the debate. Please send in further questions, comments, etc. to the hash that we have up there. If you've got any one-to-ones, by all means send those in to me and I will share them with Steph and or Michael as appropriate. Again, thank you very much to everybody for being on the webinar today and to our speakers, and we look forward to being with you on another occasion. Thank you.
Thank you.